Welcome. My name is Furchtgott-Roth, and I'll be your host today here at the Hudson Institute for a session on Section 13B with one of the leading scholars in this area, John Vecchione. For many years, the Federal Trade Commission has asserted the right under Section 13B of the Federal Trade Commission Act to freeze all of the assets of a company or individuals it accuses of deception or other wrongful acts. These injunctions are routinely granted by courts and founded on the premise that the assets will be seized by the Federal Trade Commission at the close of the litigation. Recently, courts in the Seventh and Third Circuits have ruled that Section 13B, by its terms, confirms no such power on the Federal Trade Commission. Currently, before the Supreme Court is AMG Capital Management versus the FTC, reviewing the Ninth Circuit's confirmation of this power. Mr. Vecchione is Senior Litigation Counsel for the nonprofit New Civil Liberties Alliance, representing clients against the administrative state. He was previously President and CEO of the nonprofit Cause of Action Institute, where he also advanced constitutional order. Mr. Vecchione filed an amicus brief on behalf of the petitioners in AMG Capital Management before the Supreme Court. Mr. Vecchione, welcome to Hudson. Thank you so much for joining us today.
It's great to be here. Thanks for asking me. I'll make one correction. I don't know if I'm a leading scholar. I'm a leading litigator, but I write on it, but I see what some people write, and I blush a little at that particular appellation.
Well, I insist on it, and we're very happy to have you here today at Hudson. Tell us a bit about the case before the Supreme Court.
So there were two cases before the Supreme Court, and now there's one. And it's very interesting, I think, from a litigating perspective, because they don't usually do this. The Seventh Circuit, just like Illinois, the Midwest, and the Ninth Circuit, California, those states out there, the circuits split. Seventh Circuit said, hey, all you circuits out there, we're the ones who started this. We said that the FTC had this power back in the day in a case called Amy Travel. And we were so wrong, and you've all followed us, and you've got to stop, all right? It's very unusual case. The Seventh Circuit looked at what they did. They looked at the statute, and they said, this is crazy, and everyone's followed our lead. So they ruled in that case that a huge judgment against this company and individual was null and void. In the Ninth Circuit, AMG, it's also a $1 billion case. And this AMG, I don't think there's a lot of dispute. AMG is a bad actor, right? They were a payday loan outfit that it wasn't just giving out payday loans. It was giving out payday loans, but all the bad stuff was hidden so that people wouldn't know that when they thought they were going to borrow $390 and pay back $500, they were really going to be paying back $1,000 or a lot more than that. And they accumulated like $1 billion doing this. So the issue here is not whether they're good or bad actors. The question is, can the FTC do this? And the Ninth Circuit said, yes, look at Amy Travel. That's perfectly fine. And look at our prior precedent. That's what the Ninth Circuit said. So the Supreme Court took both cases and combined them. And then about a little while ago, it dropped the Seventh Circuit case. It said, we're not going to have that before us. So it's just AMG Capital now. And my view is they dropped the one where the FTC had that power, and they kept the one where the Ninth Circuit reversed. They dropped the one where the Seventh Circuit said they don't have that power, and they took the one where the Ninth Circuit says they did have that power. So I think that's very good, because I don't think they're going to be reviewing something just to affirm.
What's the schedule for the case?
So I think that argument is in early January 11th, I believe it is. So there'll be argument on that. And when they come out with a decision, I don't know. Their first decisions of the term just came out yesterday, I'm pretty sure, for this week.
Tell us, what does Section 13B actually say?
Okay, so this is the FTC Act. So it's the Section 13B of the FTC Act. And what it says is that the FTC can go into court and obtain an injunction. That's all it says. It says they can obtain an injunction. Now, how do you get to seize billions of dollars under that? Well, what happens is there is equitable relief, damages, penalties. Well, governments can take all of that. And in fact, the FTC can do that. The FTC, in another section of the FTC Act, can have an administrative proceeding. And in the administrative proceeding, the words of the statute are much different. And they give the FTC a lot of powers here. The injunctive power was given to them to stop bad acts that somebody was doing. For instance, you're giving out payday loans and you're not telling people what the real deal is. Stop doing that. And while we have our administrative proceeding, what happened is, and we say this in our brief, it didn't happen by accident. One of the real scary things about this is there was an FTC litigator named Fitzgerald. This is in our brief. And he wrote a whole paper how, you know, the statute doesn't say this, but we got a clever strategy. Congress wouldn't be looking at us, the courts wouldn't be looking at us, and we would slowly expand our power and our ability to seize more money by using some old cases from the 40s and the 60s. One of them's named Porter. And he followed the SEC doing this. And so he said, well, we'll just expand what an injunction is. And that's what he did. And then he wrote about it. He was very proud of it. It was not like after this was done and they had the power and they had Amy travel and everything, he says, and now I'm going to, she was like Penn and Teller showing you how the trick was done. And so we put that in our brief because I think it's it's clever lawyering, but it's bad for an agency to accrue power this way.
For our audience, can you explain what an injunction is and whether an injunction can be a remedy for past action, or is it simply forward-looking, blocking future action?
That's very good. An injunction should only be issued when there's a danger of future action. It stops things prospectively, as opposed to damages, money damages, which are for injury you've done in the past. Now, there is, and so the injunction power, the government argues, and this is footnote 12 of their brief. I thought it was very funny that that's where they put it, because they know, like I know, like everyone knows, that Congress knows the word injunction. They know the word full equitable remedies, okay? Congress says full equitable remedies, and there are more equitable remedies. For instance, you can have restitution, you can have disgorgement. There are larger equitable powers than an injunction. But Congress knows a lot of words, and they know those words, and they didn't use it. They used the word injunction. And they could have said full equitable powers. They could have said damages. They could have said penalties. They did not say any of those things. So the government put this in a footnote 12. You know, they use the word injunction, but that has many meanings, and sometimes it could be the same as equitable remedies. It could be this, it could be that. So they just use the word injunction. That word has a very long history and a long meaning. Now, in fairness to the government, I will say this. There has been a line of cases that if you get an injunction, stop doing this, in order that you don't multiply cases, you can have ancillary relief. And ancillary relief, and I don't think they use the term in their brief, because if they did, as I say in my brief, it would have to do a lot of work. That's if there's some small side issue that is attached to the injunction. The court can determine that. But it's not $1 billion in damages. It's a smaller thing. It's say, okay, you stop doing this, and also you've encroached on his property, so give him that property back. Okay, so let's say you put a tent on somebody's land. He would enjoin you from putting the tent on the land. He'd say, and also you said this land was yours. It's not. That's ancillary relief. It's not exactly just the injunction. It's also ordering you do something else, but it's small in relation to what you brought the case for. And I think $1 billion is not small.
No, I think even in Washington, $1 billion is not a small sum. Tell us a bit about how the FTC. You said they started citing some cases from the 40s and the 60s. Why haven't the courts limited the powers of the FTC before now?
In this respect, we say in our brief, they have been limiting the powers of the FTC in the last 5 to 10 years. Some of this, there are other things. There was also their injunctive power. The FTC has a huge mandate. It is supposed to police deceptive and unfair practices in trade. Now, you can only imagine how wide that is given our economy. I mean, it has a huge mandate. So they were, some of the injunctions they were even getting were to stop prospective bad acts. And the Third Circuit said, well, there's no evidence there's a prospective bad act here. And so they said, just as you started this whole session with, aren't injunctions for the future? And the Third Circuit, yeah, they're for the future. So you have to show they were going to do something bad in the future. And in that case, a company had done something bad a long time ago, had stopped doing it, had changed all its practices, but they still wanted to enjoin them. And the court said, there's no evidence they're going to do it in the future. They haven't done it for years. You're just not allowed to go around pestering people who have stopped doing whatever it is. So that, and there's been a few other cutbacks, but on 13B, what happened was two things. The courts have become more textualist and more originalist. The cases they relied on to start with, the first one, Porter, was during World War II, okay? There was a national emergency like COVID. You get a lot of leeway when there's a huge war going on. And so there had been rent control, and a landlord had charged more rent, I think is what it was. And it was clear that you could enjoin that, but could you also get the other rent back? And the court said, yes, sure you can. You can get the old rent back. But that was ancillary. And in that case, Congress, it said you can get an injunction or other order. So the word was other order. That allowed them a lot of running room under that statute, I think. And there are later cases saying, nah, that wasn't the real reason. It's because these injunctions are bigger. But really, what happened is a series of Supreme Court cases came out saying, look, when Congress wants to give an agency power, it gives it power and it uses words. And then we look at what those words are. And so last term in Liu versus SEC, not FTC, Securities and Exchange Commission, they had used equitable relief. The word was equitable relief. And in that case, the court said they do have a disgorgement power, the SEC, but they cut it back to a disgorgement power because the SEC, like the FTC, had expanded what disgorgement is. Disgorgement is you take somebody's money wrongfully. There's a pot of money. The courts have said, wait a minute, you can't keep that pot of money. You've got to disgorge it because you can't profit from your own wrongdoing. So give it back. But if you have other money somewhere else, they can't take that. That's not disgorgement. That's money damages. That's you hit me in the face, right? And I get a tort judgment against you for $25,000. So then I'm allowed to go after whatever assets you have because that's money damages. And I apply that to whatever money you have. That's not equity. Equity is you've taken someone else's property or stuff and the court gives it back.
Tell us a bit about the court process that happens when the FTC seeks to apply 13B. They go to court. Is the other party allowed there? Is there a trial or how does an injunction grant it?
Okay, so this is part of how, of this power that they've taken upon themselves that is particularly troubling to me because I've represented clients in this position. You have a going business. The FTC, sometimes in conjunction with state FTCs, the states have them too, goes into court and gets an ex parte order. Ex parte means that it's just you're the party in interest. The other guy doesn't get any notice of it. It's unlike most things we do in court. Usually anything you do in court, the other side gets to see it and tell the judge why you're wrong. Ex parte orders are orders where the order is issued and the guy who it's issued against gets no say in the matter. And how it has developed and how I have seen it happen in real life is they go before a court, they have cookie cutter affidavits. And these affidavits always say the same thing. regardless of the case. And one of the things they always say is that the target has overseas bank accounts or is likely to flee overseas. Now, I have seen these affidavits with people who have never been out of the United States in their lives. They just put it in there. I mean, that's really bad practice, and I've never seen them punished for it. But the fact is, so they go in, they tell these federal courts who are likely to believe the FTC that these are bad actors, they're doing bad stuff, you got to seize the whole thing. So they then go in with the state police or whoever it is, they seize the business, they seize all the bank accounts, they seize sometimes your family's bank accounts who have nothing to do with the case, they seize every bank account, and then they say, oh, now you get to come in and challenge the injunction, the preliminary injunction that we just got. Okay, so you go down to the street and you say, hey, I've got $1 billion just been seized by the government and I need a lawyer. And they say, well, what money hasn't been seized? Because lawyers want to get paid. So what they've done is they've immediately cut you off from even having a lawyer work for you. And the amounts of money released maybe to get a lawyer, the judge sometimes does that. They don't want to do anything long-term. You get it released, they come in, they give it their best shot, or they try to settle with the FTC. They've cut off the real way Anglo-American law is supposed to work, which is a conflict of two sides arguing, because they've deprived one actor of attorneys.
Let me see if I understand this right. So a federal agency can go into court, ex parte, seek an injunction for $1 billion against a party that has no idea this is coming, and a federal judge will grant such a preliminary injunction?
Yep. Now, it's only supposed to be for 3 days to a week, but they do, and that 3 days to a week is critical. If you or I sue someone, let's say someone actually comes and steals money from us. They steal $100,000 from us. If we go to court to get that money back, you or I couldn't get an injunction because it's money damages is the way the law looks at it. And someday you'll get a judgment and then you go after it wherever it is. Now, once a case is going on, you get some discovery, maybe you could get an injunction to hold the pot of money. That sometimes happens, but this is routine for the FTC. This is routine operating. In fact, they tend to like this better than their own administrative proceedings in a lot of ways, because it is so devastating and because they always get settlements. Very few people take them to trial. These things rarely go to trial. Cause of action, we brought one to trial, but we were representing someone pro bono. When somebody has no money, they're not going to get to trial. And so whatever they seized, they keep.
Sounds a little Kafkaesque to me.
It's pretty bad, but the way this started is it's kind of a little bit like the way RICO was used. RICO was started for organized crime, right? Mafia. People who are always trying to evade the law in every way, so they expanded the law, but that's a statute, right? And then the government applied it to more and more things. In this case, it started with extremely bad actors, people who fled the country when the TRO, when the temporary restraining order came in. They would run, they would immediately confess. It's just been expanded to a lot of other areas. Because the other thing is, which has not, I don't think it's really, I don't think the courts are fully cognizant of this yet. They're kind of getting there. But let's say you have a business where you're doing something wrong. Some part of your business is doing something wrong. But most of your business is above board and you're getting all kinds of income from legitimate things that no one can complain about. But there's one thing over here that maybe your advertising's bad on this product or something. They seize all your assets for this one thing you did wrong. And if you don't get into court, you can't bring it up that, I've been running a good business. Maybe I was wrong to say that, that pill was going to cure your baldness, but that wasn't the only thing I was doing, and they seized all my assets. So that's another thing that I think is important here, because they tend to say that everything you did was bad, but that's not the case. But if you never get into court, you never got to show that. And I don't think that's the case in AMG. I mean, that is one of the tensions we always have in the law, because the Supreme Court makes principles of law. Here's what the law is, and it shouldn't matter who the parties are, but it sometimes flavors the case.
And why is it that the initial judge in the ex parte hearing doesn't say, yeah, we'll do the injunction to stop their future acts, but that's it, or yeah, you can seize assets related to the bad acts, but not the whole business?
Well, there's nobody on the other side telling him any different. What is he getting? He's getting an affidavit from the government of the United States saying these guys are doing these bad things. They're only doing bad things. Their whole business needs to be seized. And then they do something else. And this is in the Fitzgerald memo I talked about. They show this judge that all these other courts all over the land have done this. They use what they've created as precedent. But as I point out in our brief, and which I've seen, is they create precedent oftentimes by settlements and orders from unrepresented parties. So that is the same precedent. If the court looks at, Johnson versus, U.S. versus Johnson, and a court has ordered all this, and maybe that guy appealed, maybe he didn't, but it's on the books, it's in an opinion, whether he was represented or not is often not looked at. I have always felt that, an unrepresented party's case, he's not going to raise all the issues. You never really know. You want two represented parties before the precedent is really good, but that's not really how the law works. And so they show, here's this weak guy we beat up, that's precedent. Now we got this guy. And so, and all the judge is getting is a horrific story of consumers being hurt. And that if he doesn't do this, consumers are going to be hurt, and this guy's going to go to, Brazil or something. It's that, so they do it, and they figure, well, in 3 or 4 days, I'll have someone before me, and we'll make sure this is all works out in the wash. Yeah. But there's a psychological impact there. The judge has now ordered all your stuff seized. He's already decided the government thinks you're a bad guy. Is he going to undo all your assets in 3 or 4 days after he's made that decision? No, think of yourself as a human. Once you've made a decision like that, do you want to say you were wrong? Is that the way humans act?
And you said that these rarely wind up in court. They're usually settled. Do you have any sense of what percentage of these ex parte injunctions actually wind up in court?
Well, the injunctions end up in court. I mean, people do go in and say, I didn't do that, I didn't do this. Sometimes they're represented, but they don't go to trial, okay? So they don't go to trial. And I'm gonna say, I think I can say without fear of contradiction that 95% don't go to trial. And sometimes they've got a real bad actor who's walking away. Maybe there's criminal sanctions as well. He wants to go worry about those. So, because some of the things the FTC is doing is going after bad actors, sometimes in the appropriate way. But sometimes it's just catching people in its huge net because it has projects, we're going after this industry, we're going after that industry. We've decided we don't like this activity. And people get swept up in the net, but virtually none go to trial. It's very, very small because, again, how are you going to pay for it? No one is entitled to a lawyer in a civil case. These are civil cases. So you've got to get a lawyer to defend you all the way through to trial. Could take 2 years, could be very expensive. They could be discovery, there's all kinds of things. So by and large, doesn't go to trial. And so you're just stuck with it.
You just mentioned that the FTC may go after a certain industry or a certain set of practices. So this is entirely discretionary on the part of the FTC to who they're going to go after, and there doesn't have to be any evidence of any criminal wrongdoing or anything like that.
It is totally discretionary what industry they're looking at. That is discretionary. I do think there is evidence of wrongdoing because here's what does happen. They decide that they don't like a practice. One practice they don't like right now is multi-level marketing, where I think that you buy products and maybe you sell them. I'm not an expert in that area, but they don't like any of it. So they will often a company will be involved in this, and it's not a pyramid scheme under state law, under federal law. It complies with the law,
Yeah.
but the FTC doesn't like it. So they've decided that all of these things are scams, no matter whether you're really buying the product, whether you have success, whether you've agreed to everything and everything's above board, whether the parties like it or not, and the people who get the products like it or not, the FTC doesn't like it. So they've been bringing a lot of those cases. And once again, it's the same situation where somebody has their assets seized, or their bank won't lend them money or process their checks anymore because the FTC's after them and the banks get scared. And then your business is destroyed and the FTC doesn't have to prove anything. And that's really the insidious part, because I'm sure the FTC could prove a lot of this stuff for the bad actors, but when it stops you having an attorney, people who are hurt are the people who aren't real bad actors, because they're the ones who never get to go in and marshal the facts and then also fight in the appropriate way that we would fight if you're really represented. The way it's in the news now, Facebook has all these antitrust cases. So antitrust is divided between justice and the FTC, all right? Justice has this one.
Right.
The Department of Justice has this one. But
Right.
the FTC could bring it under its antitrust powers, and that's a civil case. Well, Facebook gets to fight, but does, the bookseller down the street get to fight? Probably not.
Internally within the FTC, when they want to go to court to get an injunction, is that something that has to get signed off at the commissioner level, or is this down at the bureau? Or
No, commissioners have to sign off on the case, because that's the initial thing in the case. And one of the things in the government's brief that they're very clear on is that whether they proceed administratively before their own administrative law judges, they're called, and go the administrative route, or whether they go the court route, is completely up to the FTC, they say. And they say that their argument is we get both and all remedies, which either way we go. But they say that our administrative proceedings create law and precedent for everybody, so that they know what we're doing. I don't know how strong that argument is, but I do know that that decision is made at a high level. I'm virtually certain that the FTC has to sign off on this, just like they have to sign off on settlements and they have to sign off on dismissals. So this would also have to sign off. I just know that, I know that from having litigated against what they have to bring to the commission itself.
I think it was in your brief that said something like 49 complaints were brought last year under Section 13B. So it's about one a week.
Oh yeah.
That comes up to the commission level for them. But I assume they're not given a lot of information about what's really going on. They probably get the same information the judge is getting in terms of what is in the complaint.
Well, one thing, I have never been in the FTC, and I do wonder about that. And the reason I wonder about what they get and what they don't get is that staff of the FTC has been doing this a long time. Once they believe in a case, they then find the commissioners and want the commissioners to believe in the case. So we see this, I am always wondering whether or not the higher ups know our view of the case. So sometimes we just send them a letter, but I haven't seen the letters have any effectiveness to the general counsel or otherwise, except at least then I know that whatever's happening in court, that it's not a mistake on their part, that they want to be doing this. So that's the one advantage you get when you actually send a letter to the general counsel rather than the line attorneys. But the line attorneys they'll tell you very frankly when you're trying to settle a case, I can't do that. They'll never let me. So the FTC commissioners have their own agendas as well. I mean, they do. You can see it when they dissent. You can see, just like the Supreme Court dissents, sometimes the FTC commissioners write a dissent on a case that's been picked. And then of course the accused, the person on the other side raises that dissent in every case on earth. We weren't doing anything wrong, you know. Only so I don't think it's a matter of, you know, the czar is deceived. I don't think that. I think it's a matter of they may not be fully informed. They never see a loss coming. That's the thing I don't understand about the big agencies. Both the FTC and the SEC always think they're going to win for some reason. They always act like it, and they always go for it. And then they lose, and they go, "Oh, I can't believe this happened." And they go to Congress, and they say, "Oh, we don't know why we didn't get this power." And they always tell Congress it was the court's fault. Anyway.
Speaking of which, tell us about there was a letter sent by all 5 FTC commissioners to Congress in October. I thought it was an extraordinary letter.
Is this the one that they were afraid that this power was going to be taken away?
And they asked Congress to give them the power they thought they always had,
Yes.
which was
Well, yes. So this. I was alluding to that in what I just said, because they issue a report every year where they tell Congress how much money they've seized. And there's what I call the top line number and the bottom line number. And the top line number is they get injunctions for huge amounts of money, but the people they sued don't have that amount of money. So it's just a paper number, right? It's very big. And then there's the amount they've actually seized, which, you know, for us is very big, but it's not quite the same. So they have seen this assault on this power. It's been going on for a little while. Lawyers have been bringing this up for a little while now. I'd say maybe 7 years. It's been percolating through the law. Mm-hmm. So now they've been going to Congress to say, look, change the language, which from our perspective, that's how you're supposed to get these powers. I mean, it is how you're supposed to do it. But then they come in, they tell the courts they already have this power, and they tell Congress we need this power. And there will be, since I think that the Supreme Court will cut back this power, they may not perfectly define it because the issue I told you earlier that there is ancillary relief with an injunction, and the scope of ancillary relief is not hard and fast right now in the Supreme Court precedent. There may be some wiggle room on that, but I think they're going to get this, hey, you can take $1 billion. That stuff's going by the boards. So then they'll go to Congress, and we'll see what Congress has to say about it. Because that's the other thing that's kind of unfair here. Congress listens to the FTC. Congress takes everything the FTC says seriously, because they're always going to be able to bring in a bad actor and say, look at this guy, he's getting away with murder. And what are the Congress going to say? Congress is going to say, oh no, you need this power to stop that. The person who hasn't done anything and who gets caught up in the web is never going to be before Congress because they don't know what's coming. The FTC knows. So if they did get the law changed, well, that's getting the law changed. But it is interesting that they are very worried about these cases. The fact that the 7th was quickly followed by the 3rd Circuit in a very well-written opinion, I think has them very concerned, because the 9th has held out, but the way the law is going, in words mean something, which I think is the way the law always should have been. They're concerned with that because they know what words mean. They read just like you and I read.
But you point out that the FTC can always bring, there are bad guys in the world, no question about it. They're bad guys, and some of them probably get caught up in this. There are also people who are not bad guys who get caught up in this because there's overzealous government bureaucrats who want to go after them. And in your brief, you actually mentioned small business in Florida, I believe.
Biola Tech, yeah.
Tell us about that case.
So Biola Tech, I represented them, and Cause of Action represented them. And this was a small computer company that provided computer protection, all right? And the FTC created one of its programs was Operation Tech Trap, where they said that all these organizations were using lies to get unsophisticated people on the hook for all of these computer protections. Well, our clients were actually providing computer protections, all right? And they had a problem with some of the pitches when people called in. And to be fair, the court found that our clients were liable under the statute for for some of their statements to customers from the early part of their business. So they got summary judgment. The FTC got summary judgment. But we said, but wait a minute, these people are getting the product. There's no damages. You can't show there was any damages. You've got they're liable. You could get an injunction. I mean, they're liable under the statute according to the court. But what are your damages? So we took them to court. I want to go back for a bit. They got one of these injunctions at the very start. Client couldn't get any attorneys. They came to us eventually. They were represented pro bono. So that's how they were able to do it. They'd had 2 or 3 attorneys who dropped out or had to drop out or couldn't do anything. And they got that injunction. And we took an appeal to the 11th Circuit before the case was over. And we said, look, the wife doesn't own the company. She's not involved in this. The brother he lives on the other side of Florida. He's never done anything. And all his assets have been seized. And the 11th Circuit said, yeah, that looks bad to us. How do you go around just... So then they came into court, and I'll never forget this because it was really amazing. The district court had done everything they wanted. She'd gotten partially reversed on this one thing. She gave them a chance to have a hearing, with us there too. I mean, it wasn't like it was ex parte like they got against us. And they came in and they said the same thing they told her at the beginning. But look, and she says, I'm paraphrasing, but she says, I am not going to seize someone's assets because they're related to somebody else. Do you have anything else? And then she was obviously, I've always seen the look on her. I've always thought she felt that the government had behaved badly there. And so then, so their assets got unseized, and then we went to trial, and the government couldn't prove any damages. They gave, I think it was nine different totals. And the judge there, he was from Minnesota. He was down there. I think he was a Twins fan, and they have spring training in Florida. And so we had this Minnesota judge down there in Florida, I think, going to Twin game, and he said, no, you didn't prove your case. Now think of all the people who didn't, and now the receiver had spent all the money, so the client didn't get that much back, but whatever was left, they got back. Business was destroyed, and the judge had found that a lot of their income streams, it was the situation I told you before. Nothing wrong with this. Even the government admits there's nothing wrong with these income streams, and yet the whole thing had been destroyed. So that's a bad thing, and that's for a company that was liable under the judgments of the court for certain things, but it wasn't liable on other things. But no one gets to show where they were right and where they were wrong if you don't ever get to court.
John, let me just see if I understand this. This is so chilling. The small business, this is not some big company, it's a small business. They're selling computer virus protection services or whatever. They may make a couple of exaggerated claims to some customer. Otherwise, it's a legitimate business. And the federal government goes in ex parte, gets all the assets seized for the company, and the wife of the owner and the brother?
Yes. And they had tangential relationships to any of the bank accounts. The brother had helped, I think the brother had helped form the company, like he had shown them how to put the papers together, and then he left. He hadn't done any of the actions, no actions. And so they seized it. And the other thing they did is they put in one of those cookie cutter affidavits that these guys, they could leave. They were Americans. Well, the wife, I think, was from South America, but they were all Americans. They didn't go, they didn't have property abroad or anything. They weren't, they weren't, some sort of gang that has all kinds of members in Venezuela or somewhere. They were Americans like you and me. They lived right there. They weren't going anywhere. They just built a big building because their business was so successful. They wanted to expand, so they were expanding down there in Fort Myers. They weren't buying property anywhere else or doing anything else, but that was in the affidavits, and that was not true. And it's really bad. But yes, their business was destroyed. They did they were at least vindicated that about what had happened. I mean, there had been no consumer complaints. This isn't something where people are calling into the FTC. I missed that.
There was no consumer complaint?
Not before this all happened. But then the government shut down the business and people weren't getting their computer services, so they really started complaining.
Well, yeah, my jaw is on the ground. How did the FTC find out about this if there were no consumer complaints?
Disgruntled employee.
Oh, disgruntled employee. Okay. Are there other federal agencies that have the power to do what the FTC did under Section 13B?
The SEC is similar, but the SEC doesn't have, in my view, as broad a mandate. The problem with the FTC is unfair or deceptive trade practices.
Who knows what that
means?
Yeah.
And the FTC doesn't like making rules. They are allowed to make rules, but they don't make rules and say, all right, if you're doing this, we're coming after you. That's wrong. Like we know, for instance, the EPA can do certain things. It can seize property. The EPA has certain, but the EPA, to its credit, makes a lot of rules. The EPA says, don't do this, don't do that, don't do the other thing. The FTC proceeds by litigation, and they regulate by litigation. And it's litigation where there's no one fighting on the other side a lot of the time.
Wow. This is very, very chilling. And so
well, the other thing is, I will say this about, there's another thing about the FTC, because it is an independent agency.
Yeah.
Its heads have to be like a certain amount of Republicans, certain amount of Democrats. They're staggered. So the FTC, one of the things I find amazing, and it's just very strange, because you've read the Constitution, you're familiar with it. We have an executive branch, a congressional branch, and a judicial branch, right? Well, the executive branch is supposedly run by the president, but in one of the cases against Qualcomm, it was, because it came out, I was representing a client, it was the last week of the Obama administration, and two cases were released by the FTC. They brought two cases, one against Qualcomm, one against my client. And so I followed them both at the same time, but this went up to the Ninth Circuit. This was also in California. And Qualcomm had a judgment against it in the district court. It was reversed in the Ninth Circuit. But in that case, the Justice Department said, this isn't wrong. They're allowed to do this. And the FTC said, no, they're not allowed to do this. So you had the executive branches telling the judiciary two different things, because the FTC is not bound by what the Justice Department says. It's really amazing.
Well, I think in that case, the commissioners were deadlocked too, because Chairman Simons was recused, and so it was the staff in charge.
Yeah.
Yeah.
So in any event, but that is an unusual thing, that the executive department is at war with itself on an issue of law that affects, hundreds of thousands of people and billions of dollars in profits, and they don't agree, but you're still faced with a court case.
Tell us about what would happen if the court reins in 13B and tells the FTC, you can do what the statute says, you can get an injunction, but you can't use it for equitable relief. You can't seize past it. Does the commission have other remedies at law?
There's three things that'll happen. First, Congress may act and say, now we want them to have this. That could happen because they're going to be lobbying to beat the band for that. But again, the other side will have a say in that, and they'll say, well, what about this? Can they take that much? What protections do we get? Because Congress will be interested in the protections. It just won't be this open-ended. The second thing is they can they could do an administrative proceeding and then go into court in aid of the administrative proceeding. So let's say you have an administrative proceeding against a bad actor, and you've brought it against him. It's before your ALJ. Your ALJ can't issue, can't seize property or do any of that stuff. but he can certainly go to the courts and say, in aid of my proceeding, could you hold this? Could you stop them from dissipating assets? If there was an injunction against dissipating assets, this is one of the closer questions, right? Can you do that when you have an administrative hearing? In my experience, federal courts are very solicitous of administrative hearings. They let them go forward first a lot of the times. They will do things in aid of them. So it's not the end of the world. The other thing is, since the administrative hearing, you're allowed to get damages, penalties, all that stuff. So you could use the federal courts, which I think the way they were supposed to be used, which is stop doing this while we have our administrative proceeding. That's what I think is supposed to happen with the statute.
Right, but at least in that case, the other side gets a chance to present its case, and presumably the injunction that the administrator would seek might be simply to stop some activity.
Right.
Which, in the case of your computer service company, they had already stopped, it sounds like. So
right, but let's say there was a false statement they didn't like. Stop making that false statement.
Yeah, okay.
And if you can't sell things without making that false statement, maybe your business collapses, but it's a different thing from...
Very different, yeah, very different. Yeah. Well, there certainly are appropriate uses of injunctions to stop bad acts from...
Right, stop, don't say this thing, don't say that thing, or the other way you could do an injunction is you can say you have to reveal, this part of your contract that you're not revealing. There's things you can do to say you can't do this to customers and get those injunctions. I don't think there'd be any problem with that. Stop saying this, or if you're going to say this, you also have to say that. I think those are the type of injunctions that are usually upheld if they're true. And so it's not like all these bad actors will get off the hook. The FTC might have to change its practices, how it does things a little bit, but it will still be able to stop the bad actors. What it won't be able to do, and this is important for all of these regulatory agencies, especially FTC, its bailiwick is so broad, so huge. You can't be expanding its powers by stealth. It's one thing if you go to Congress and expand your powers, and Congress has made the decision that there are more bad actors than innocent parties affected, and we're not really worried about this. Congress says that, well, sometimes that's what happens in life. But it's another thing with an administrative agency that is just off going on its own, going by itself with no direction, expanding its powers without Congress passing a law, the president signing a law, the courts okaying the law. Just the courts slowly allowing, we let him take, that little bit of land I talked about earlier because he shouldn't have been putting his tent on it anyway. And so they're that little thing to billions and billions and billions of dollars a year in awards to the FTC. Because the other thing that might happen here, because there's one other issue I think that's interesting, and it came up in the Liu case, and the government's pounding it hard here, and I think they may be asking for a brushback from the courts. Under equity, when you take money from the bad actor, it's supposed to go to the injured party. In these cases, it often goes back to the Treasury, to the government. Yeah. There's some dispute whether the awards the FTC gets are going to the injured parties is a contested issue, all right? Are they really going to this consumer? Now, some of them really are. The FTC does get money back in the pockets of people, but how much of that is for the consumer? How much of that is the FTC? I think that's still a contested issue. But the court may say the only way you get equity is if you find, if there's the party you can give it back to. You have to know who the injured party is and get it back to them. Because equity is very tactile. It's very specific. This is the wrongdoer. This is the hurt person. It's not like there's a general wrong in society, so we can correct this general wrong by punishing this person abstractly.
Mm-hmm. Right, and but coming back because I'm just I'm deeply troubled by your case down in Florida. So but there's no remedy for people whose lives have been destroyed by this either.
Well, sometimes there's a question, I think, in the law right now whether the receivers can be sued. Usually the courts say no, they can't be sued, but if they dissipate the assets or something while they have it, or if they tell the court something wrong, maybe. I have never seen anyone be made whole from an improper administrative proceeding against them. They're just it just doesn't really happen, and it's a terrible thing. I mean, particularly, to be fair, the courts in the last 5-6 years in the Biola Tech case, the 11th Circuit was kind of annoyed, and then the district court got annoyed when it was brought to their attention. But again, those people were represented pro bono. If they weren't, what happens to them? They don't even have a little line in an order saying this was wrong.
Yeah, it's completely wiped out.
And I talk to businessmen all the time. I get calls all the time. How can we stop this? How can we do this? And I tell them, I said, very difficult. You've got to get some kind of pro bono representation, and then I see later on they've just settled whatever it was, even if they've had a good case, even if all the parties on either side of the transaction were happy. If the FTC is not happy, it has a bludgeon to really stop it.
Tell us a bit about the New Civil Liberties Alliance.
So the New Civil Liberties Alliance was founded by Professor Phil Hamburger up at Columbia, and he's written a book called "Is Administrative Law Lawful?" It's I just saw a little thing on Seinfeld. It's like it's airing of grievances against the administrative state, because there are a lot of things here. I'll give you an example. One thing that really is unusual is how do they get courts to give them money damages with no juries, right? Happens in administrative law all the time, but we have a constitution that says over $20 in damages and money damages, you get a jury to decide that. And I always joke that $20 amount reminds me of the Austin Powers, where Dr. Evil goes $1 million because he's been in cryogenic freezing too long, so he doesn't know that's not enough to ruin the world. So the $20, but they get money damages. They don't have the protections that courts have. And Professor Hamburger thought that and thinks that this is the way more Americans will be subject to administrative courts than to our courts of law, to our federal courts. It's like 10 times the amount. It's some huge number like that. But who is protecting the civil liberties of the people whose rights are affected by that administrative army, really? Because there's tons of these ALJs, tons of these courts, tons of various ways that you can be affected. So he founded the New Civil Liberties Alliance, and we represent people before administrative agencies, or we go into court to stop an administrative agency from doing things on behalf of various clients. And we're pro bono. We're not a law firm. We represent parties without legal fees, and it's primarily aimed at making sure that the administrative state stays within the bounds of what the Constitution and the laws that Congress passed has granted them legitimately.
Well, you're doing wonderful work. I've had Professor Hamburger's book for many years, but actually I just recently read it cover to cover, and candidly, I think it's the best book on legal critique I've ever read, and it's deeply, deeply troubling. And so I'm glad to know that you all are doing something about it.
Yeah.
Go on, but I don't want to tax your time. And thank you so much for joining us today here at the Hudson Institute. We've all learned a lot, and we will keep our eyes on this case before the Supreme Court.
You're welcome. I think everyone's going to be watching it, particularly the FTC.
Yes, right. Okay. Thank you very much, John.